Welcome to You Counsel. 3 days ago, on May 29th, 2020, the Ontario government made certain changes to Employment Standards Act under its regulation called Ontario Regulation 280/20, which temporarily takes away certain important rights that employees had previously during the COVID-19 emergency. What are those changes? What are those rights that have been taken away? We will briefly explain that in today's lecture. We begin with our usual disclaimer that this lecture is not legal advice. If you have any specific questions, you should contact a lawyer or paralegal or the Law Society of Ontario if you require a referral to a lawyer. Now, there are two kinds of changes. One is that employers have a right now to reduce or eliminate the employee's hours. And then the second right is that the employer has to reduce employees' wages. And the third thing that I want to mention is that the common law rights of employees are intact. So these are rights under Employment Standards Act, but the common law rights are intact. But let's explain what does this all mean. Let's begin with the reduction or elimination of hours. Now, this is the link for the regulation. I've provided it. I will also provide it in the description of this lecture so you can visit this regulation and understand it in more detail. First of all, what you want to understand is that these changes that have been allowed are for the duration of COVID-19 emergency plus 6 weeks. So the day when the emergency is considered terminated, for an additional 6 weeks, the employers will have these rights available. So they start from March 1st, 2020. They continue until the emergency is ongoing. Once the government announced that the emergency is ended, then beyond that, for 6 more weeks, the employers do have these rights to reduce or eliminate an employee's hours. Now, the reduction or elimination of hours must be related to COVID-19. How do you go about determining whether an employer's reduction or elimination of hours is indeed related to COVID-19? That is anyone's guess, but that is one of the requirements. Secondly, the most important part you want to understand is that employer has this unilateral right now to reduce or eliminate any employee's hours. So prior to that, if you understand a little bit of employment law rights, if you were entitled to, let's say, 40 hours per week of hours in your employment, and if the employer wants to reduce your hours to 30 hours or 25 hours, you will have to agree to that reduction of hours. If you do not agree to that, then you get into a situation called constructive dismissal. You were ordinarily allowed to go file a complaint with the Ministry of Labor or commence a court action in court, and then you will be able to get compensation on that basis. Now, this unilateral change is allowed. This means that the employer is not required to seek approval, agreement from the employee. Employer can make those changes unilaterally. And what the regulation indicates is that because of that change, the employee no longer has a right to claim constructive dismissal under the Employment Standards Act. Previously, you did have that right if you were an employee. Now, you no longer have that right to claim constructive dismissal under Employment Standards Act during this time period. If you file a complaint, obviously you should not file a complaint because you do not have the right to do so now. But if you do file a complaint with the Ministry of Labor on this issue, on the reduction or elimination of hours, not any other issue, then under the regulation, it specifically states that it will be considered that no complaint has been filed. So the assumption is you cannot file the complaint. Now, the only saving grace here is that if your hours are completely eliminated, then you still have a right to reinstatement at the end of the emergency plus 6 weeks. So your job is still intact, even though you're not earning any money because your hours are either eliminated or reduced money because your hours are reduced, but you still have a right to reinstatement. However, if your position is completely eliminated at the end of the emergency period plus 6 weeks, then obviously you don't have a position to go back to, and then in that case, your employment is terminated, and at that time, your termination rights will be triggered. Similar principles apply to reduce wages. The employer can now, during COVID-19 emergency plus 6 weeks, can, on grounds related to COVID-19, reduce an employee's wages unilaterally. Again, it's a unilateral change. Employee, if you are making $20 an hour and if the employer decides to reduce your wages to $14 or $15 an hour, as long as it is not below the minimum wage, the employer can do that and it does not require your approval. And similarly, you cannot claim constructive dismissal under the Employment Standards Act. You cannot go to the Ministry of Labor and file a complaint because, again, the complaint will be considered not filed. Again, if your wages are zero, that that means you had no hours, you still have a right to reinstatement unless your position is completely eliminated, in which case your termination rights will be triggered at that time. Now, I mentioned that the common law rights are intact. So if you understand a little bit about the regime of different kinds of entitlement for employment law in Ontario, and if you have listened to any of my previous videos or watched the lectures, you would know that you could have rights under Employment Standards Act, and you could have rights under common law, which are enforced by the court. If you are pursuing your rights under Employment Standards Act, then you go to Ministry of Labor. There's no cost for you. You file the complaint. The Ministry of Labor inspector gets appointed. He or she will investigate and make a decision. So there isn't really any burden on you other than filing a complaint with the Ministry of Labor, and then they will take over and then look after that matter. But there is a limitation with respect to those kind of complaints, because Ministry of Labor's complaints are within the four corners of the Employment Standards Act and nothing beyond that. If it is a common law dispute, they do not even have the power or jurisdiction to deal with that matter. So these changes are relating to Employment Standards Act. It is relating to the Ministry of Labor's power. So Ministry of Labor now under Employment Standards Act cannot give you those rights for constructive dismissal, for reduction of your wages, reduction of hours. But you can still go to court, because under common law rights, if there is a reduction of wages or reduction of hours, and that is unilateral, then you can claim constructive dismissal under common law and you may be entitled to damages. So those rights are still intact. Now, the takeaway from all of this is that what the indication from the regulation is that this loss of rights is temporary. It is only for during COVID-19 emergency and plus 6 weeks. And the idea, I believe, is that if you were temporarily laid off and your termination rights are triggered because of the original Employment Standards Act, not the one that is now changed, then it would have triggered your rights for termination and severance pay, and that would have caused significant burden to employer, who now has to run the business despite all the challenges of COVID-19 and pay out the termination and severance payments to various employees. So the government in this situation, what they're thinking behind all of this is that allow the employers some breathing space so they can continue to operate. But the problem is that while allowing the employer the breathing space, this is taking away significant rights from employees, and so their rights are affected. The only part that you want to keep in mind is that only the rights under the ESA are affected. Common law rights are not affected. So what is the impact of this? There is a disproportionate impact on low wage earners, because higher wage earners who have the capacity to hire a lawyer and go and file a claim in courts may still be able to go and apply for their common law rights and get those rights given to them through the courts. However, for low wage earners, it is harder for them to retain lawyers, and therefore the negative impact of this is that low wage earners who would previously go to Ministry of Labor to have these rights enforced do not have any venue now to enforce these rights. We will keep you updated on any further changes as they come along, but thank you for watching.